Oh, I got it. Okay,
Oh,
sorry.
okay.
Maybe it's gone because we don't need it. Okay, Mr. Seeger, we do have Ms. Scarlett connected here. Right here. Bring her in. Okay, Ms. Scarlett, are you able to hear me okay?
Yes, I am.
All right, so we'll go on the record in People versus Ashley Scarlett. This is file number 265171. The record should reflect Ms. Scarlett is appearing today by video by prior approval of the court. If I could have counsel put your appearances on.
Ryan Ziegler on behalf of the people, Your Honor.
Thomas Seeger appearing with an on behalf of Miss Scarlett.
Thank you. Mr. Seeger, can you tell me the status of this file this morning?
Your Honor, there has been a contemplated offer. However, at this time, Miss Scarlett is not inclined to accept it. And so I would ask the court to, one, docket the matter for trial. And second, if the court is willing to give us one final settlement conference in an attempt to resolve it in advance of trial.
Okay. Mr. Ziegler, could you just make a record of what the plea offer is?
Your Honor, the current offer is that Ms. Scarlett could plead guilty to count one, which is a possession with intent to deliver methamphetamine. In exchange, the remaining counts and enhancements would be dismissed.
Okay, thank you. Ms. Scarlett, have you heard what the lawyers have had to say so far?
Yes, I have.
Okay, is that correct? You wish to proceed to trial?
Correct.
Okay. Mr. Ziegler, how many days of trial do you think we?
On the conservative side, Your Honor, I think 2 days.
I think that that's a fair assessment, Your Honor.
Okay, so we'll set a 2-day jury trial. If we set that 60 to 90 days out, Mr. Ziegler, is that enough time for you to be ready?
That should be sufficient.
Mr. Seeger?
Agreed, Your Honor.
Okay. And then, Mr. Seeger, I will set it for a final status conference. And that will be the plea cutoff and the motion cutoff. So, Ms. Scarlett, the court will send you the notice of the date and time of your trial, as well as the final status conference. It's important that you stay in touch with Mr. Seeger between now and then, so that you're prepared to go forward. Do you have any questions about how we're going to proceed with your case?
No, I do not.
Mr. Seeger, are there any other dates we need to address for your side?
No, Your Honor.
Mr. Ziegler?
No, Your Honor.
All right, thank you. Do you have any questions, Ms. Scarlett?
No.
Okay, thank you. That's all for this hearing today, and you're free to disconnect at this time.
Thank you.
Okay, ma'am, what's your name?
Jessica. Well,
Okay. You want to come up to the podium, please? We'll go on the record in People versus Walker. This is file number 265184. The record should reflect Ms. Walker present here in the courtroom today. And Mr. Seeger, how did you want to proceed in this file?
Your Honor, there is a motion that's pending. I was unable to get a date in advance of today's date, and then apparently the July docket is full. And so when I had spoken to the clerk, it's my understanding that I think the next date that was available was 8/3. And so I will file the motion and the notice this week. But that was the next date that was available to argue the motion.
Okay, so we need to have that heard and decided before we can proceed further with scheduling.
Yes, sir.
Mr. Ziegler, anything from the people?
no, Your Honor. I think it makes sense to hear the motion first, and then we may have a plea after that or not.
Okay, Ms. Walker, do you have any questions about how we're going to proceed with your case?
No, at this time, no.
Okay, so again, it's important that you stay in touch with Mr. Seeger throughout this process so that he can help you prepare your case, okay?
Yes.
Thank you, that's all for today.
And this is Mr. Kite, Your Honor.
Okay, Mr. Kite, if you come up to the podium, please, go on the record in People versus Kite. This is file number 265169. The record should reflect Mr. Kite is here present in the courtroom today. In fact, we have both counsels of your appearances in this file.
Ryan Ziegler on behalf of the people, Your Honor.
Thomas Seeger appearing with an envelope, Mr. Kite.
And Mr. Seeger, can you tell me the status of this?
Sure. It's my understanding that Mr. Kite, and I don't know if the court recalled, but previously there was some discussion about whether or not we could allow him to plead under 7411, and then probation and parole were able to determine that he was ineligible. And so we set this matter over. In between, there was an old file that got caught up with this one. It was bound over yesterday. But my understanding of the plea offer is that he would plead to the possession in this case, and in exchange, the new file that was bound over yesterday, together with a misdemeanor, would be dismissed.
Okay. Is
Fair
that,
statement, Your Honor.
okay, so Mr. Kite, have you had an opportunity to speak with Mr. Seeger about this plea?
Yes,
agreement?
sir.
Okay. And is that how you wanted to proceed today?
Yes, sir.
Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, yeah.
Thank you. Mr. Kite, are you currently on any probation or parole?
I am currently on probation for a delivery of Schedule 1, 2, or 3 out of Grand Traverse County. I was placed on that in September.
Okay. That was after this incident?
Right.
Yes.
Okay. All right. And you understand that by pleading guilty to this charge here today, which is possession of fentanyl, that the maximum penalty you could face would be up to 4 years and or a $25,000 fine?
Yes, sir.
With that in mind, what is your plea to that charge today?
Guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, sir.
You understand that you're giving up and waiving all of those rights by pleading guilty.
I do.
Has anyone threatened you with anything to get
No,
you?
Your
Has anybody promised you anything other than what we've said here on the record today?
No, Your Honor.
Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty to this charge because you are actually guilty?
Yes, sir.
The information I have indicates that this happened back on August 23rd of 2025. Is that the correct date?
I believe so, Your Honor. Yes.
On that day, were you here in Kalkaska County?
I was.
While you were here in Kalkaska County, did you have possession of some fentanyl?
I did.
Did you know that that's what that substance was?
I did.
Did you have any legal right to have any amount of it at that time?
No, Your Honor.
Mr. Ziegler, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Seeger?
Yes, Your Honor.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Seeger?
No, Your Honor.
Mr. Kite, I forgot there was one other thing that I needed to advise you of. You don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave, and that means that you would have to ask for the Court of Appeals to hear your case. If they said no, then that would be the end of the appeal. Do you understand that?
Yes, sir.
Does that change anything about your willingness to enter into this plea?
No, Your Honor.
With that, Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Ziegler, or Seeger?
Yes, Your Honor.
Thank you. Mr. Kite, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there's a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. And Ms. Wagner, do you want Mr. Kite to stop by the probation office today?
Yes, please, Your Honor. Thank you.
So before you leave today, Mr. Kite, just stop next door at the probation office and they'll give you a packet for a pre-sentence report.
That's across the way then?
Yes. Yep. And then just make sure that you stay in touch with Mr. Seeger pending that sentencing hearing.
Okay.
Do you have any questions?
No, you don't.
Thank you. That's all.
Thank you.
Mr. Patrick is on the courtroom too. Yeah.
Okay, Mr. Patrick, if you would come forward, please. We'll go on the record in People versus Dustin Patrick. This is file number 265195. The record should reflect that Mr. Patrick is present here in the courtroom today. If I could have counsel for your appearances on this file.
Ryan Ziegler on behalf of the people, Your Honor.
Thomas Seeger appearing with and on behalf of Mr. Patrick.
Thank you. Believe this is the first hearing here in circuit court in this file. Mr. Seeger, can you tell me the status of this case?
Your Honor, it's my understanding that Mr. Patrick is going to tender a plea to possession, which would be treated under 7411. In exchange, the balance would be dismissed.
Okay. Mr. Ziegler, is that a correct statement of the plea offer?
It is, Your Honor.
And Mr. Patrick, have you had an opportunity to talk to Mr. Seeger about this plea agreement?
I have.
And is that how you'd like to proceed today?
Yes.
You raise your right hand, please. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Mr. Patrick, do you have any prior controlled substance related convictions?
I've had one more DUI.
Okay, but not anything relating to
No, not
drugs?
No.
Okay. And I asked that because the 7411 statute
Gotcha.
allows you to do that one time. Okay, and are you currently on any kind of probation? Or
I'm not.
and you understand that by pleading guilty to count one, which is possession of cocaine, that carries with it a maximum possible penalty of up to 4 years and or a $25,000 fine.
I do.
With that in mind, what is your plea to that charge?
Guilty.
Right now, you have certain rights. I'm going to go through those rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want to. You understand all those rights?
I do.
And you understand that you're giving up those rights by pleading guilty.
I do.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you would have to ask for the Court of Appeals to hear your case. And if they said no, that would be the end of that appeal. Do you understand that?
I do.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we said here in court today?
No.
Is it your own free choice to enter into this plea?
Yes.
Are you pleading guilty to this charge because you are actually guilty?
Yes.
The information I have indicates that this happened on September 14th of last year, 2025. Is that correct?
It's correct.
And on that day, were you present here in Kalkaska County?
I was.
And while you were here in Kalkaska County, did you have possession of some cocaine?
I did.
Did you know that that's what that substance was?
Yes.
Did you have any legal right to have any amount of it at that time?
I did not.
Thank you. Mr. Ziegler, are you satisfied with the factual basis?
Yes, sure.
Mr. Seeger?
Yes, sir.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Seeger?
No, sir.
And Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Seeger?
Yes, sir.
Thank you. Mr. Patrick, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of this charge. The court will accept the guilty plea. As I told the previous gentleman, we'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. It's important that you stay in touch with Mr. Seeger between now and then so that you're prepared to go forward on that date. And also, before you leave today, we'll need you to stop by the probation office next door to get a packet for a pre-sentence report. Do you have any questions about
I
that?
don't.
Thank you.
Thank you.
Right, next hearing is at 9:30. Ms. Berge, do we have Ms. Berge?
They have her. They haven't brought her up. Yes, sir.
Okay.
And Mr. Thornburg also.
Okay. So as soon as they're, okay, I can, yeah, we can do it early.
Okay.
Thank you.
Shipped to the jail. You want to bring up or me?
All right, we're on the record in two files, file number 265-207 and 265-161, People versus Rose Berge. If I could have counsel put your appearances on, please.
Ryan Ziegler on behalf of the people, Your Honor.
One Seeger paying with on behalf of Ms. Berge.
Thank you. This is the date and time set for sentencing in file number 5161, and then Mr. Seeger, at your request, we also set the new file. I believe that was just found over last week. How did you want to proceed, Mr. Seeger?
Your Honor, it's my understanding that Ms. Berge is going to tender a plea to 265207, which the offer was that she could plead to use, which would be limited to court costs and fines, which was part of the reason why I tried to get it taken care of while we're here for sentencing.
Okay, so we would move directly to sentencing in the new file.
I have no objection unless the Department of Corrections or the prosecuting attorney wishes to do something different.
I would prefer to move right to sentencing, Your Honor.
Are you going to be asking for any additional jail time on that file?
On that file, no, Your Honor.
Okay. Ms. Wagner, is there any reason from your standpoint that we couldn't proceed to sentencing on the new file today?
No objection. I'm good with that.
Okay. All right. Ms. Berge, have you had a chance to talk to Mr. Seeger about this?
Yes, sir.
Okay. Is that how you want to proceed as well?
Yes, sir.
Okay. So we'll address that file first, Mr. Seeger, and take the plea. And move to the sentencing portion of this. And so you said that there was going to be added count 2 of use.
Correct, Your Honor.
Okay. And take the plea to the factual basis of count 1.
Yes, sir.
Okay. Mr. Seeger, or Ziegler, is that correct?
That's correct, Your Honor.
Okay. Ms. Berge, if you could raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Ms. Berge, you understand, is this a 1 year?
Yes, Your Honor.
Okay. So you understand that this charge that you're going to be pleading to, which is use of a controlled substance, is a misdemeanor that carries with it a maximum penalty of up to 1 year.
Yes.
With that in mind, what is your plea to that charge today? Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand all those rights.
Yes, I do.
And you understand that you're going to be giving up those rights by pleading guilty today. Has anybody threatened you with anything to get you to plead guilty? Has anyone promised you anything other than what we've said here in court today? Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty because you are actually guilty?
Yes.
The information I have indicates that this happened back on March 9th of this year. Is that correct? And on that day, were you present here in Kalkaska County? And at that time, did you have possession of some Adderall?
Yes, I did.
Did you know that that's what that was?
Yes, I did.
Did you have any legal right to have that substance at that time?
I did not.
Mr. Ziegler, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Seeger?
Yes, Your Honor.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
No, sir.
And are you both satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Yes, sir.
All right, thank you. Ms. Berge, as to that matter, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there's a factual basis to support a finding that you are guilty of that added charge of use, and the court will accept your guilty plea. And then in terms of sentencing, I'll address both files at the same time. So, in the other case, we were set for the sentencing hearing today. And there was a pre-sentence report that was done. Did you have a chance to go through that with Mr. Seeger?
Yes.
Okay. Mr. Seeger, are there any additions, deletions, or corrections to
They're
that?
not, Your Honor.
Are there any challenges to the scoring?
They're not, Your Honor.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
Your Honor, just that the PSI does not address restitution in the matter. I believe that the defense's intention is to apply their bond to cover the restitution. The restitution amount should be $675 payable to Jeremy or Jerry Hines.
That is true, Your Honor.
Okay. 675, you said?
675 even, Your Honor, payable to Jerry Hines.
Okay. Thank you. Any other corrections?
No, Your Honor.
No, sir.
Okay. And I see on the older file, there's 3 days of jail credit. Is there any jail credit on the new charge?
So she would have been sitting since the arraignment, Your Honor, which was, looks like May 6th was the arraignment. She was probably arrested the day before. So May 5th would give her 28, 29 days of credit.
29. Thank you. Okay. And Mr. Ziegler, do the people have any challenges to the scoring?
I do not, Your Honor.
Okay, and then in terms of allocution, if you can address the older file and then just maybe address some of the facts on the new file as well.
Certainly, Your Honor. As to the file involving the larceny in the building, I would just ask the court to adopt the recommendations of the PSI author. I think the term of jail being recommended is appropriate, especially given that she reoffended while on bond in this case. I think the term of probation being recommended is also beneficial both to Ms. Berge and to the community at large. Ms. Berge has a long history of substance abuse and dysfunctional relationships. I think those two factors have contributed significantly to her both perpetrating crimes and being the victims of crimes here in this county. I think a term of probation may be helpful to help her refocus her life on more productive endeavors. So I think that the recommendation makes perfect sense to me. I'd ask the court to adopt it in the instant file. As to the use file, Your Honor, it's a case where she was on probation for the check matter. She was in a vehicle. She was found to have a small number of Adderall pills on her person. She said they were not hers, but that she knew they were there. I don't think that I don't think it really weighs heavily given what we're already here for today from Ms. Berge. I don't think it merits any more jail time than what she's already done. I would just ask the court to impose time served on that file and preserve any fines and costs for collection. Thank you, Your Honor.
Thank you. Mr. Steve.
And Your Honor, similarly, I would just ask the court to give a credit for time served as it relates to all file, to place her on probation for a period of time. One of the primary components of this plea was that she was able to make restitution. To my understanding, the bond will be applied and hopefully that will resolve restitution. I think that monitoring will be an important function for Ms. Berge. She has been involved in a lot of, just like Mr. Ziegler didn't get a lot of toxic relationships, such that I think that has impacted her ability to, at certain times, make good decisions for herself, which has led to other problems. In any event, Your Honor, she has expressed a great deal of remorse. She has expressed a want to remain sober, and hopefully she's able to continue in that endeavor. So I would just ask the court to consider just placing her on probation for credit, with credit for time served.
Thank you, Ms. Berge. Is there anything you wanted to say today?
Sir.
I did read through the file, so I'm familiar with what happened in this particular case. And then through counsel, I've got some information on the facts in the new case that we just took the plea on. There's also a lot of information in here about you and your background and circumstances and so forth. And so I take all of those things into consideration when looking at what is an appropriate sentence in this case. And I do think some punishment is warranted. This looks like to me a crime of opportunity. You had a chance to get a hold of this checkbook and wrote yourself some checks out of it that you knew you didn't have the authorization to do. And that's a circumstance where, you really have a choice of, am I going to do this or am I not going to do it? And you chose to do it. And so I think that does warrant a degree of punishment. And I think the recommendation is appropriate in that regard. But I also think that probation is appropriate here too. It looks like, you've been on probation a couple other times from the report. It looks like we're successful on those terms. So I have every expectation that you would comply and be successful this time as well. And I do think, as the lawyers have indicated, some supervision might be helpful to you in terms of trying to get you on the right track. So I think that's absolutely appropriate as well. So the court in file number 5161 is going to sentence you to probation for a period of 2 years. The court is going to adopt as the conditions of that probation all the terms and conditions that are listed in the report. The court is going to order that you serve 6 months in the Kalkaska County Jail, credit for 3 days served, crime victims assessment of $130, restitution in the amount of $675 payable to the Kalkaska County clerk to be dispersed to Jerry Hines. Court costs of $325, attorney fees of $350, DNA testing fee of $60 and a $68 state cost, as well as a $30 per month supervision fee while you're on probation. In file number 5207, I agree with counsel that I think time served is an adequate penalty for that charge. So the court will simply impose the statutory fines. I'm not going to reimpose new court costs or attorney fees on that file. The court will simply impose the crime victims assessment of $130 and the state costs of $68. You do have the ability to seek an appeal of this sentence. Oh, I'm sorry, 29 days in jail with credit for 29 days. Nothing. Mr. Seeger, can you provide those appellate rights to Ms. Burby?
Yes, Your Honor.
You don't have to give the additional case of the others on that today. Thank you, rights to. I don't know to read. Can I get the PAP code for the added charges?
It's 333.7404. 2B is in boy.
Thank you. Thanks, Ed. Do I get to go home today?
No, unfortunately, the court's imposing a jail term on the larceny charges.
Okay.
Well, meeting time. Yeah. And Mr. Thornton.
Okay, perfect. Thank you. All right, Mr. Thornburg, if you can go right up to the podium there, please. This is the date and time set for sentencing in this matter. Mr. Thornburg is present here in the courtroom. If I could have counsel put your appearances.
Ryan Ziegler on behalf of the people, Your Honor.
Thomas Seeger, appearing with on behalf of Mr. Thornburg.
And this is file number 265117. And again, Mr. Thornburg's present here in the courtroom today. And Mr. Thornburg, did you have a chance to go through the pre-sentence report and talk to Mr. Seeger about that? Okay. Mr. Seeger, are there any additions, deletions, or corrections to that report?
There are no additions, corrections or deletions, but there are some disagreements about the characterization of the report itself.
Okay. And I can, if you want, you or Mr. Thornburg can address those in allocution. Are there any challenges to the scoring?
They're not here.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution?
Your Honor, Mr. Thornburg's record is atrocious. There's really not much anyone can say about that. And his record is primarily what's bringing him before the court with guidelines of 2 to 17. However, the incident itself in this case is kind of a mixed bag. Factually, he was apparently arranging a drug deal with another individual who was a CI, but then had someone else conclude that drug deal or continue those negotiations. When the narcotics team showed up, MSP's fugitive team decided to arrest him on his outstanding warrants rather than go through with the deal. When they did the search of the vehicle, they didn't find the drugs, the 3.5 grams that were being arranged for anyway. All we ever found in the vehicle on Mr. Thornburg's possession was residue. So factually, this case is a very murky story that ends up with the defendant only in possession of some fentanyl residue. That obviously is very different from a PWID case, and it's very different from catching him with the actual 3.5 grams TNT expected to find. His guidelines of 2 to 17 are an intermediate sanction cell, Your Honor, which practically speaking means that 6 months is right in the middle of the presumptive outcomes in this case. Given that his record is terrible, but his offense is relatively on the low end of what we might expect for a possession charge, I think a sentence in the middle of the guidelines is appropriate. And I think that's why Mr. Seeger and I came to the agreement that we did in this case for a 6-month cap. I think it's reasonable under the circumstances to give him more punishment than most people would get in just a possession of residue case, but certainly much less punishment than someone without his record. It's just a balancing act, Your Honor. So I would simply ask the court to follow the agreement of the parties to give him 6 months in jail consecutive to any parole sanctions that he might face as a result. Thank you.
Thank you, Mr. Seeger.
Your Honor, I don't have an objection to the court imposing a 6-month jail sentence to the extent that the court feels that's necessary. However, I would ask the court to hold that time in advance to the extent that he's able to get into treatment. Probation and parole have sent to the court, or presumably will send to the court, notice of his admission into treatment. When he took the plea, the court had been apprised that he was trying to get into treatment. The court had indicated at that time it didn't have any objection and wouldn't get in the way of him getting into treatment to the extent that he was eligible for it. And speaking with the prosecuting attorney's office, it's my understanding that they don't have an objection to him getting into treatment at his earliest point, if that's possible, which will require the court to hold the sentence in advance. And even if it was greater than 6 months, if it was 12 months, to the extent that he's getting into treatment, I think that probably balances things. In terms of the way that the report reads, I do agree that it is murky. Arguably, we were going to have a trial, but then we ended up entering into a plea. But Mr. Thornburg denies it's untrue that he was in the process of or was going to sell anyone anything. In any event, Your Honor, he does have a substance abuse problem. He was going through some mental health crises. While he's been incarcerated, I think the report also bears out that he was trying to commit suicide at one point in time. So that probably somewhat indicates a person who definitely needs to address his underlying mental health problems together with some substance abuse problems, which I'm sure don't help him in any way. He did indicate that he wants to be a good role model for his child. While he's been incarcerated, he's been taking care of the things that he can take care of, including classes. He does have some certificates of completion from Catholic Human Services. He's hopeful that he can put himself back on the right track. I know that the court doesn't have to give him credit for time, and statutorily it can't because he was on parole. However, he has served an appreciable period of time incarcerated and has now come to the point where he's hopeful that he can get into treatment and he can transition his way back into society. He was working. He does have skills. He does have the opportunity to put this behind him and at least hopefully become somewhat financially sound, such that hopefully he doesn't find himself using substances as a crutch to perhaps ameliorate some of the other problems that he has, and maybe he'll be better focused on work and responsibilities to his family as opposed to using drugs. So in any event, Your Honor, he's hopeful that the court will give him the opportunity to get any treatment. I've known Mr. Thornburg quite a few years, and there have been different moments in our relationship where I think he struggled. Clearly, he's continued to struggle. But at least in this moment, when I had talked to him in this case, he was not wholly defiant. He was definitely invested in the idea of changing his life situation. He was invested in the idea of maintaining his sobriety. And above all else, Your Honor, he did indicate that the most important thing to him going forward was to be there for his child and to, I guess he can't undo what he's done in the past, but he can at least try going forward to be a better role model for his child and make better decisions. But he's just hopeful that the court will allow him to get into treatment. And again, Your Honor, I did speak with the Department of Corrections. They will have to clean up the parole hold for Mr. Thornburg, but he has immediately, they will not get in the way of him getting the treatment. They also endorse him getting into treatment, and he does have a bed available to him as soon as the parole matter is resolved.
Okay. All right, thank you. Mr. Thornburg, anything you wanted to say today?
Since I've been incarcerated, I know that my time is bedtime, so to speak. I've sat 5 months now, but I didn't just sit there and do nothing. I actually took upon myself to actually try this time instead of just faking it to make it. And I mean, I know it's pretty obvious if somebody doesn't want to do drugs, they just don't do them. And I always thought it was that easy, but it's not, at least not for me. I completed 2 classes in there, and I am dealing with some, depression, anxiety type stuff. I lost my dad and my grandma before this happened, and I'm not going to say that's the reason why I was using it. Just I wasn't able to deal with stuff like that without having a crutch or something like that. So I recently just got this Sublocade shot, and I've always turned away from it because before, when I was wanting to use, I didn't want to do the shot because it would interfere with me using. But I just got it this morning. They actually gave me the injection at Wexford County Jail. And I've been in touch with ATS. I've been calling them, talking to them. I've been going to AA, NA, and I've been taking it serious. I don't want to continue living like this. I got a little baby boy out there. He's 16 months old, and I miss my other 2 kids' lives because I've been in prison because of just horrible choices. And I don't want to keep doing it, keep going through that. And the last year of my life is getting away from drugs. It's very difficult. But I am trying.
Okay. Well, I read through the report, so I'm familiar with the circumstances here based on that information, and I've listened to what both the lawyers have had to say about the underlying facts. Of course, there's a lot of information in that report about you and your background and circumstances, prior record, and so forth. I did get the confirmation from ATS through the Department of Corrections, so I'm aware of that. I also received a letter, I think, from one of your employers that wrote in as a character letter for you. So I take all of those things into consideration along with what the agreement was between all of you in terms of a sentence. And I do think it's appropriate. I think, things are lining up in this particular instance for you to have that opportunity to go to treatment and to get some help. And like you just said, I mean, it's up to you at that point to decide whether you really want to change or whether you're just looking for an easier path out of jail. So I hope that that you do make that choice to change because you're almost 40 years old, or are you 40 yet? Or
I just turned 40 on May 15th.
okay, so yeah, you're getting to the age where I can see where this would be getting old.
Exhausting.
So, we're going to give you that chance. And so again, I hope that you take advantage of that. I am going to follow the agreement of the parties. The court is going to sentence you to 6 months in the Kalkaska County Jail. Again, you don't have any credit because of your parole status. And the court is required by statute to make that consecutive to any parole sanction. However, and as I'm sure you're aware, that parole violation issue's got to get resolved, I think, before you could be released to treatment under any circumstances, because that has to come first before this does. But I don't have an objection to holding any remaining time on this sentence in abeyance. If you can get released to treatment through Department of Corrections. And I'll give you day for day credit on that 6 months for any time that you do spend in treatment if you successfully complete the program. And you wouldn't be required to return to jail if you successfully complete the program, or it'll continue to hold that time in abeyance. However, if you don't, participate in the program, then you'll have to serve the 6 months. If you go into it and, you leave or don't successfully complete it, then you'll have to return to jail and you won't get credit for the time that you were in treatment. So there's a big benefit to you in terms of that 6 months to get into treatment as quickly as possible and to complete it successfully. And I hope that that's the way things go. And if not, then it'll just be a matter of serving that 6 months. So the court is also going to impose a crime victims assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. You do have the ability to seek an appeal of this sentence. You can provide Mr. Arnberg with a acknowledgement of those. Thank you. Did Mr. Arnberg get?
He did, Your Honor. It's return a copy of Stone's.
Good luck to you going forward.
That's it.
That's all. Yeah.
Okay, thank you, Steve.
Your Honor, I think that closes my docket. I think.
Okay, thank you. Mr. Travis, did you have any clients you were ready with? I know we're a little ahead of schedule, but
Mr. Ronald Schmarzak.
okay. You can just stay right on the end there, sir. Yeah. You should be able to get.
Thank you.
Yeah. You'll be able to get your voice. Recording. And how do you pronounce your name?
Last name is Smarsh. First name is Ronald, and I'm a junior.
Okay, Smarsh. This is file number 265190. The record should reflect Mr. Smarsh is present here in the courtroom today. If I could have counsel put your appearance.
Brian Ziegler on behalf of the people, Your Honor.
Kyle Travis on behalf of Mr. Schmarsh.
Mr. Travis, can you tell me how we're going to proceed in this file here today?
Yes, Your Honor, we did waive a prelim based on an offer. I believe this was initially discussed as a 7411 plea, but my understanding that there is I think a use.
The use, yeah.
From some years ago. So then the offer would be a possession of narcotics. And I believe Mr. Schmarsh would like to accept that.
That's the 4-year?
That is.
Okay.
Correct statement, Your Honor.
Okay.
Yes.
Mr. Smarsh, is that the plea agreement that you've discussed with Mr. Travis?
Yes, sir.
And do you need any more time to talk to him about that, or did you want to proceed with that?
We go ahead and proceed with that.
Okay, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Mr. Schmarsh, are you on any kind of probation or parole at this time?
No.
And you understand that the maximum possible penalty that you could face for, again, it's just possession of a controlled substance?
Possession of narcotics.
Narcotics. For possession of narcotics is up to 4 years in jail or prison. Do you understand that?
Yes, sir.
With that maximum possible penalty in mind, what is your plea to that charge today?
Guilty, Your Honor.
So right now you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at a trial. You have the right to remain silent during that trial and to not have that silence used against you, or the right to testify yourself if you wanted. Do you understand that you have all those rights?
Yes, sir.
And you understand that you're going to be giving up and waiving all of those rights by pleading guilty?
Yes, sir.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave. So if you wanted to try to appeal it or get it reversed, you would have to ask for the Court of Appeals to hear your case. And they could say no, and then that would be the end of that appeal. Do you understand that?
Yes, sir.
Has anybody threatened you to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we said here in court today?
No, sir.
Is it your own free choice to enter this plea?
Yes, sir.
And are you pleading guilty because you are actually guilty?
Yes, sir.
The information I have indicates that this happened back on April 1st of 2026. Is that the correct date?
Yeah, around that time, I do believe.
Okay. And at that time, were you present here in Kalkaska County?
Yes, sir.
And while you were here in Kalkaska County, did you have possession of some methamphetamine?
Yes, sir.
Did you know that that's what that was?
Yes, sir.
Did you have any legal right to have any amount of it at that time?
No, sir.
Mr. Ziegler, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Travis?
Yes, Your Honor.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on record?
No, Your Honor.
No, Your Honor.
Are you both satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Yes, Your Honor.
Thank you. Mr. Smarsh, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there's a factual basis to support a finding that you are guilty of possession of narcotics. The court will accept your plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing.
Okay.
It's important between now and then that you stay in touch with Mr. Travis. And then before you leave today,
Exactly what you're getting to.
okay, we're going to need you to go next door to the probation office and check in with them.
Okay.
Do you have any questions at all?
No, sir.
Okay, thank you.
Thank you.
Tax code. Yep, it's 333.74032A5.
Ma'am, are you Miss? Are you Miss Powell?
Yes, sir.
Oh, I'm just gonna have you go right up to the podium there.
Alright.
Thank you. Go on the record in People versus Howe. This is file number 265189. The record should reflect that Ms. Howe is present here in the courtroom today. If I could have counsel put your appearances on.
Ryan Ziegler on behalf of the people, Your Honor.
Kyle Travis on behalf of Mrs. Howe.
Is this our first appearance?
It is, Your Honor.
Okay, can you tell me the status of this file here today?
Yes, Your Honor. Similarly, Ms. Howe did waive her prelim in this matter based on an offer. It's a 2-count complaint. Count 1 would be dismissed to a plea to count 2, resisting and obstructing an officer, a 2-year max. And it's my understanding that's how Mrs. Howe would like to proceed.
Mr. Ziegler, is that a correct statement of the plea offer?
It is, Your Honor.
Ms. Howe, is that the plea that you've discussed with your lawyer prior to today?
Yes, sir.
Do you need any more time to talk to him about that, or are you ready to pursue that?
I'm ready to proceed.
Okay, raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
So help me God.
Thank you. Lower your hand. Ms. Howe, are you currently on any kind of probation or parole?
I am currently doing BBD tests during the week.
Okay,
And
You're on probation in Georgia.
yes, on First Offenders Act plea bargain from the state of Georgia. I transferred it to here in Charlotte in Eaton County and and then from there I came here and I received the I've been coming up to the jailhouse every morning to do PBTs. But as far as what happened was they dropped the one here in Charlotte and it went back to the state of Georgia, which automatically caused me to have a violation of my probation under First Offenders Act, second degree or something like that.
okay.
It's about-
So are you still on probation in that case, or is that over with?
I'm not exactly sure. I know that an officer had told me that I do have a warrant in Georgia,
Okay,
but I haven't talked to them up there yet because that's where I'm originally like living and my daughter is.
all right. Well, I don't know if you're still on probation there. If you get a conviction here, that could be a violation of your probation. Do you understand that?
I do understand that.
And I don't have any control over what Georgia may or may not do about that. But you understand that you could face a penalty there for violating your probation because of what happened in this case.
Oh God, yes, I do.
Okay.
Mhm.
And then you understand, in this case, you're pleading guilty to resisting or obstructing, and that carries with it a maximum possible penalty of 2 years and or a $2,000 fine. Do you understand that?
Yes, sir.
With those things in mind, what is your plea to that charge today?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand that you have all of those rights?
I do.
And you understand that you're going to be giving up and waiving those rights by pleading guilty.
I do.
Has anybody threatened you with anything to get you to give up and waive your rights?
No, sir.
Has anybody promised you anything to get you to plead guilty?
No, sir.
Is it your own free choice to enter into this plea?
Yes, sir.
Are you pleading guilty because you are actually guilty?
Yes, sir.
The information I have indicates that this happened back on March 13th of 2026. Is that the correct date?
Yes.
On that date, were you present here in Kalkaska County?
Yes.
Did you come into contact with some deputies from the Kalkaska County Sheriff's Department?
Yes.
You know that did you know at that time that they were police officers?
He was fully uniformed.
Okay. And they were there doing their job as police officers. Is that
Yes,
correct?
sir. Mm-hmm.
And what happened? Did they give you some commands that you didn't obey? Did you physically resist?
Well, I currently, last June, I got into a really bad car wreck and I have a bar in my back. I have a lumbar from spinal cord 4 to 2 and a bar from hip to hip. And what I did was I said, sir, don't touch me. Don't grab me. I have a bar in my back and it'll be really hurtful. Well, so I didn't run. I wasn't obstructing. Like I wasn't being chaotic. I ended up putting my hands behind my back and I guess where it hurt so bad, where he grabbed me too hard, I just automatically out of pain, I think I kicked or popped or something along those lines. But as far as in like really being like against the law, that wasn't with me. Like I wasn't trying to do that, if that makes any sense. I just I'm still healing from the bar in my back.
So you were kicking at the officer?
I guess whenever he pulled me back and put me on the ground, it was like a knee or it was a knee or a shin or something like that, or an elbow. I don't know. Honestly, I want to pull the cameras. I have the cameras, but I've not seen it. Oh,
Mr. Travis, I don't know if you have more factual.
So prior to that, though, the officer was trying to get you to come near him and you weren't listening prior to that also.
oh, really?
Do you recall that?
Yeah, well, I was in the woods and he was on the ground. So he walked up to the woods and I was still there. I couldn't go very far. I was in a snowsuit,
But you didn't initially listen to his commands at that point, correct?
obviously.
Okay, so you didn't,
I didn't do, yes, I was against his commands, I suppose, at that moment,
Okay,
which put it in obstruction.
right. Okay, Mr. Ziegler, are you satisfied with that as a factual basis?
I am, Your Honor.
Mr. Travis?
yes, Your Honor.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
No, Your Honor.
Are you both satisfied that the court has complied with statute and forego in the taking of this plea?
Yes, Your Honor.
Yes, Your Honor.
Okay. Ms. Howe, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there's a factual basis to support a finding that you are guilty of this charge, and the court will accept your guilty plea. We'll set this matter for a sentencing hearing, and you'll be notified of the date and time of that hearing. It's important that between now and then you stay in touch with your attorney so that you're prepared to go forward on that day. And then also, before you leave today, we need you to go next door to the probation office, and they're going to explain the process of, they're going to do a pre-sentence report. So you need to follow through with that as well. Do you have any questions?
No, sir.
Thank you. That's all for today. Okay, Mr. Travis,
Yes, Your
I don't know
Honor.
if you have,
Sorry about the light, sir. I moved the cart, so I won't do that again.
do you have any clients that you're ready?
Your Honor, I believe Mr. Taylor's in custody. I would need just a minute to speak with Mr. Massey. And I'm not sure.
They're both.
Mr. Okay, are they? Mr. Willoughby, our 10 o'clock, I think, was being brought by MDOC. That's the suppressed file.
Okay.
And I haven't seen him around yet.
Okay.
And I know
Okay.
there was some emails about maybe having him come by Zoom, but I don't think that ever had a conclusion.
Not signed in. So, all right. So let's just take a short recess then. And if you can just let Chris, let the court officers know when they're ready. Thank you.
Keeping it either who left you guys to.
Yes, precisely, which makes me wonder.
Is this Mr. Willoughby
No, this is Mr. Taylor, Your Honor.
or Mr. Taylor? Okay. All right, we'll go on record in People versus Taylor. This is file number 255106. The record should reflect that Mr. Taylor is present here in the courtroom today. I have counsel put your appearances on.
Ryan Ziegler on behalf of the people, Your Honor.
Kyle Travis on behalf of Mr. Taylor, Your Honor.
Okay, this is set for a probation violation hearing today. Mr. Travis, how did we want to proceed today?
Thank you, Your Honor. Your Honor, we were intending to enter a plea. I think last week, Ms. Wagner sent out an email with a plea offer and a recommendation on this matter. I have informed Mr. Taylor about that. It's my understanding he would like to plead guilty to count one, which is a possession of methamphetamine. About 2 weeks ago on the underlying case, he entered a plea to a possession of narcotics in front of Judge Hunter. He's got a sentencing coming up the week of the July 8th or 7th. I'm not sure what Judge Hunter's day is, maybe the 8th on that case. And he is aware, and I have informed him that you're not bound by Ms. Wagner's recommendations, but he is aware of what the recommendations that are there. And it was a 7411 case. Obviously, he would lose the 7411 based on this plea.
And do we want to move to sentencing today?
We would be asking if Your Honor was willing, we very much would.
Okay. All right, Mr. Ziegler.
I would support that, Your Honor.
Okay. All right, Ms. Wagner, was there anything you needed to add?
No, Your Honor, nothing other than that was put in the email. Thank you.
Okay. Did you represent Mr. Taylor in that other case that you just entered the plea in?
I do, Your Honor.
Did they take a factual basis to the methamphetamine?
They did, Your Honor.
Okay. All right. Mr. Taylor, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Mr. Taylor, you understand that you would have the right to have a hearing as to whether or not you violated your probation?
Yes,
And that by pleading guilty, you'd be giving up that right?
yes, sir.
Okay. And you understand that, although the recommendation is for 90 days, it's my intent to follow that. But the maximum possible penalty here is the same as your underlying charge, which is the possession of methamphetamine up to 10 years. Do you understand that?
Yes, sir.
With those things in mind, what is your plea to the probation violation today?
Guilty.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we stated here in court today?
No.
Is it your own free choice to enter into this plea?
Yes.
Are you pleading guilty because you did violate your probation?
Yes, Your Honor.
Okay. Back on February 20th of 2026, were you on probation here in Kalkaska County?
I was.
Were you aware that one of the conditions of your probation was that you were to not use or possess any controlled substances unless they were prescribed to you?
Yes, Your Honor.
In honor about that date, did you possess methamphetamine?
Yes, Your Honor.
The court finds that your plea is knowing, voluntary, and accurate. The court is satisfied, based on your testimony here today, that there is a factual basis to support a finding that you did violate your probation as alleged at count one. The court will accept your guilty plea. Ms. Wagner or Mr. Ziegler, was there anything either of you wanted to say regarding sentencing in this matter?
No, Your Honor, thank you.
I would just ask the court to adopt the recommendations in the email, Your Honor.
Okay, thank you. Mr. Travis.
Thank you, Your Honor. We similarly would ask Your Honor to adopt the recommendations in the email. Mr. Taylor has been held since this event happened. I think he's got over 110 days of jail time in, and he is facing a sentencing on the new felony charge next month. And he's maybe of a pretty great concern. He will be losing his 7411 status because of this. So he'll now have 2 felony convictions, which he had none as of a few months ago. So he's Also in speaking with him, this time of incarceration, I think is the most he's ever faced. And it's been, I think, quite eye-opening to him to have to spend an appreciable amount of time in the county jail. And when he speaks to me, he speaks about very much getting it this time, acknowledging that he didn't really get it the first time around, and that he doesn't want to continue abusing substances, and that he very much wants to be out there helping his family and going to work and doing the right things. So I'm quite hopeful that unfortunately it had to get pretty messy for him, but going forward that he will do much better. Thank you.
All right. Ms. Wagner, in your email, it indicates 98 days of credit as of today. Is that correct?
That is correct.
Okay. Mr. Taylor, was there anything you wanted to say to them?
Yeah, Your Honor, I've learned my lesson on this jail stay, and it was an eye opener, and I got it now. I mean, I need to be back out in society, working, taking care of my family, paying my child support, seeing my kids.
Okay. All right. Well, I did review the file prior to today's hearing in preparing for the docket today. I was aware that there was the potential that we were going to enter into a plea today because I got that email from Ms. Wagner and what she was recommending. So I'm generally aware with your circumstances and what brings you before the court here today in terms of the probation violation. And I do hope that you do take this seriously. I would highly, encourage you to seek some treatment or counseling. It's really difficult to do on your own. And
Right.
even though you feel confident now, that might change. And so
Right.
the best thing you can do to prevent relapse is to get help and to get counseling.
Yes.
Because they can give you the tools to deal with those issues that come up that cause people to relapse. So I would really encourage you to do that. Otherwise, I'm going to follow the recommendations. The court is going to sentence you to 98 days in the Kalkaska County Jail. You do have credit for 98 days served. The court is going to order that you be discharged from your probation unsuccessfully, which would also include revocation of 7411 status. The court will preserve any outstanding fines or costs. You do have the ability to seek an appeal of this sentence. You probably don't.
No, I don't. I'll get it to you.
So we'll provide you with those appellate rights. It's important that you leave a mailing address with the court so that we can mail those to you. And then, Mr. Ziegler, is there anything else that we need to address from your side today?
No, Your Honor.
Ms. Wagner, anything further we need to address?
No, Your Honor. Thank you.
Mr. Travis?
Nothing further. Thank you.
Good luck to you going forward, Mr. Taylor.
Thank you, Your Honor.
See you soon, buddy.
Okay, Mr. Travis, your next case.
I have Mr. Massey for sentencing.
And I'm assuming you still have not,
I have not seen anything regarding MDOC for Mr. Willoughby. And I think 10:45 is Mr. Bucco. He's I think going to Zoom from the Antrim County Jail.
see. Yes, come on forward. Massey, if you can come right up to the podium there, please. And we'll go on the record in People versus Massey. This is file number 265172 and 5173. The record should reflect that Mr. Massey is present here in the courtroom today. If I could have counsel put your appearances on.
Brian Ziegler, on behalf of the people, Your Honor.
Kyle Travis on behalf of Mr. Massey, Your Honor.
Okay, this is the date and time set for sentencing in this matter. And Mr. Massey, have you had a chance to go through the pre-sentence report and talk to Mr. Travis about that?
Yes.
Mr. Travis, are there any additions, deletions, or corrections to that report?
Not substantially. I guess a question Mr. Massey raised, which I think I know the answer to, but we'll raise it. There's the $60 DNA testing fee. He indicates that he's had that done in the past, so I didn't know if that had to be ordered again or not.
No, so I will take that out. I'm satisfied with, based on Mr. Massey's prior record, that he has been tested and given that sample. Any other changes?
No, Your Honor.
Okay. Any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Ziegler, do the people have any additions, deletions?
Yes, Your Honor. Part of the agreement was that the restitution on the misdemeanor file was going to be preserved for collection. It's not addressed in the report. The police report indicates on the misdemeanor file that a laundry basket was stolen. It was worth about $16. I would just ask the court to include a restitution of $16 payable to a Christopher Garrett, 2 R's, 2 T's.
Thank you. Any other corrections or changes?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution?
Your Honor, I support the recommendation. I don't think Mr. Massey is a good candidate for probation in this case. There's a few reasons for that. First and foremost, his prior record of 5 felonies and 17 misdemeanors does not suggest that he is likely to reform with an additional opportunity at probation. Second, this is a 2021 case, and so is the misdemeanor larceny case that was dismissed as part of the agreement. Mr. Massey had outstanding warrants on those 2 matters for about 5 years. I don't think that recommends him well to court supervision either. Thirdly, the fact that after he did resurface and he was placed on bond for this case, he was reoffending again. He was caught with controlled substances in the other file that's being dismissed. Again, that does not give me good confidence that he would do well on probation. So for all of those reasons, Your Honor, the guidelines are 5 to 23. Given his history, I think a 12-month sentence is more than fair to Mr. Massey. I think his record, his history of non-appearance, and his reoffending on bond would certainly justify a prison sentence in this case if the court were so inclined. But I would simply ask the court to adopt the recommendation contained in the report.
So I just have some questions, Mr. Ziegler, just because of the interval between the date of the offense and the date that the charges were issued. So was Mr. Massey, out of the state?
I don't believe he was out of the state.
Do you have
Your
any
Honor.
idea like what was going on during that period of time that law enforcement wasn't able to locate?
I don't have an explanation for why he did not appear. I believe Mr. Travis had, if my memory serves, Your Honor, Mr. Travis had been appointed. We had scheduled a preliminary exam and then he failed to appear for the preliminary exam. And then in terms of what his whereabouts were in those intervening years, I don't have an explanation for the court.
So it was charged back in
21, correct, Your Honor.
just the larceny or the,
The larceny and this file were both charged in 21, Your Honor.
okay,
And then he failed to appear, I think, on the misdemeanor for the arraignment, but on the felony, I believe he appeared for the arraignment, was appointed counsel, and a preliminary exam was scheduled, and then he failed to appear.
so how did we end up with 2-6 file numbers if it was charged? And that was my confusion.
So this court's file numbers would be 2-6 because they were bound over in 26.
Okay,
But then the district court's file number will reflect a 21
okay, so it sat in district court with a bench warrant
for 5 years.
and then once he was arrested, they got bound over and, okay.
Correct. So this file would have a 21 number in district. The other one would have a 26.
I was just trying to understand a little bit better because I mean, to me, that's certainly a factor here,
Agreed.
the amount of time. Okay, thank you, Mr. Travis.
So, yes, Your Honor, to that point, when they get bound over, I realize that it gets, the number gets generated at the bind over. I believe these were not that it matters that much, but a 21 and a 22 case number on the in the district court file.
Okay.
If I recall, the misdemeanor I think was a 21 and the felony was a 22.
Okay.
So they were filed. And I would note, Mr. Massey was not anywhere else. He's not a man of means. He was here local. So as much as on one hand, that's not a good thing. On the other hand, that's 4 years of not having police contact, which, you know, I would view as somewhat positive, even if maybe the reasons or the motivations weren't maybe the most positive. It's good to not be a subject to an investigation or being involved with law enforcement for 4 years. But we would ask Your Honor to follow the recommendations. The one thing we would ask the court to consider is if he could get into a rehab, if the court would allow that towards the end of his sentence. Often I've told him that the court will even allow a day-for-day credit in those scenarios. I have, in the interim, represented one of Mr. Massey's cousins who actually brought him to a few of the court hearings. And she has been doing quite well, staying clean, and was quite, you know, happy to talk to me about how she's doing well and her motivations to try and basically help some of her other family members do as such. And I was happy to see that Mr. Massey was associating with her when he was out on this file. I think he can talk to you some more about his desire to even though I understand he's not a good candidate for probation, he still has a desire to work on getting clean and staying clean. I don't think that's been generally his situation for the past few years, that he has been clean, but he does come before the court motivated and has at least one very good family support who's very much enjoying being sober for about the last year and a half and happy to encourage any of her family members and support them in that path. So thank you, Your Honor.
All right. Thank you. Mr. Massey, anything you wanted to say today?
I've got a substance abuse problem, and I'm glad for this time in jail right now. I've been clean for a few months now, and I feel a lot better in life right now. I see I still need to cut out a few friends out of my life that are not good for my sobriety. They just bring me down, and it's not good for me, my family, and true friends that love and want to see me sober and clean. And I long to stay being sober again. I miss and love the clean life so much better. I have congestive heart failure, and both my brothers already have pacemakers as well. My mom's health is not the best either, as she's up there in age. And I just want to be there with my family, since I know we don't have forever in life. So I just want to get back to loving a clean and sober life again and be with my family before we start passing on.
Mr. Massey, I did read through the report, and so I'm familiar with the circumstances that led to the charges in this case. There's also a lot of information in that report about you and your individual circumstances, and I take all of that into consideration, along with what you've had to say here today and what the lawyers have had to say. I think, you know, the guidelines in this case are 5 months to 23 months. So the court would be within the guidelines to send you to prison for almost 2 years. I don't think that's called for given the nature of the offense. And the recommendation is kind of in the middle of the guidelines, which I think is a fair recommendation. I really don't see a lot of mitigating factors here. You know, you avoided prosecution for these offenses for a number of years. And, you know, it's not like these things were just going to go away. And we haven't addressed this, but I'm assuming that you didn't turn yourself in on this, that you were picked up for something else. So it's not like you decided, okay, now I'm going to take responsibility and get these things taken care of. You know, I mean, you avoided this for as long as you possibly could until you couldn't avoid it anymore. And I think giving you any kind of break on the sentence is sending the wrong message. And that is that, hey, if you just avoid your court case, you know, and wait as long as you can, and then later ask for leniency. I don't think that sends the right message to do that. So I'm not going to allow for any kind of sentence held in abeyance or any release to treatment or anything like that. The court's going to require you to serve the full amount of the time because I think you deserve that based on your attempts to avoid dealing with this for so long. I also think probation isn't appropriate given the information in the report. It indicates you've been on probation for 8 times previously. If one of those 8 times didn't work, I don't think the 9th time is going to be the one that does the trick. So I'm not going to commit any community or court resources to probation because I don't find that it would benefit either you or the community to do that at this point. And so I do think the recommendation is fair. I think it accounts for your conduct. And the court is going to follow that and sentence you to 1 year in the Kalkaska County Jail. You do have credit for 69 days served. The court is going to order a crime victims assessment in the amount of $130, court costs of $325, attorney fees of $350, state costs of $68, and restitution in file number 2125703 payable to the Kalkaska County Clerk, be dispersed to Christopher Garrett out of $16. You do have the ability to seek an appeal of this sentence, and Mr. Travis, if you can provide Mr. Massey with his appellate rights, please. Travis, has Mr. Massey received his appellate rights?
He has, Your Honor, and signed an acknowledgement.
I think Mr. Massey, you are remanded to the custody of the county at this time.
Thank you. Thank you. Well, there you go.
All right. Are you Mr. Bucco?
Mr. Bucko, yes.
Okay. All right. We'll go on the record in People versus Bucco. This is file number 265197. The record should reflect that Mr. Bucco is appearing today by video from Antrim County Jail. If I could have counsel put your appearance on, please.
Brian Ziegler, on behalf of People, Your Honor.
Kyle Travis on behalf of Mr. Bucko.
Mr. Travis, can you tell me the status of this file here today?
Yes, Your Honor. We did waive a prelim based on an offer. At the time of the prelim, the offer was to dismiss the habitual offender notice. Since then, Mr. Ziegler and I have had some discussions that actually started at the prelim. It's my understanding that they would offer an attempt on count 1 with no habitual offender enhancement, making it a 1-year max, and that Mr. Bucko would like to accept that offer.
Is that a correct statement of the offer, Mr. Ziegler?
It is.
Mr. Bucko, were you able to hear that?
Yes, sir.
And is that the plea agreement that you've discussed with your attorney?
Yes, sir.
Is that how you want to proceed today?
Yes, sir.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Thank you. You can lower your hand.
Thank you.
Mr. Bucko, are you currently on any kind of probation or parole?
Yes, I'm on parole right now.
Okay. So you understand that because of your parole status, that you would not be entitled to any jail credit on this charge?
Even on a misdemeanor?
Correct.
No, sir, I wasn't aware of that. But yes, sir.
Is that something that you would like to discuss with your attorney further?
No, sir, that's fine.
Okay. And then you also understand that if there's any penalty for violating parole, that any sentence on this case would have to be served after that. In other words, consecutive or back to back, not at the same time. Do you understand that?
Yes, sir.
And then, as Mr. Trevis indicated, the maximum possible penalty that you could face for this charge would be up to 1 year in jail and or a $2,000 fine. Do you understand that?
Yes, sir.
With all of those things in mind, what is your plea to the attempted tampering with electronic monitoring device?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you wanted. Do you understand those rights?
Yes, sir.
And do you understand that you're going to be giving up and waiving those rights by pleading guilty?
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we've said here in court today?
No, sir.
Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty because you are actually guilty?
Yes, sir.
Okay, so the information I have indicates this occurred back in March of 2026. Is that the correct time frame?
Yes, sir.
All right, and as a condition of your parole, were you required to wear some type of electronic monitoring device?
Yes, sir.
And did you attempt to remove that device contrary to your parole conditions?
Yes, sir.
Okay. Mr. Trevis, are you satisfied with the factual basis?
Yes, Your Honor.
Mr. Ziegler?
Yes, Your Honor.
Oh, I'm sorry. Did that occur in Kalkaska County, Mr. Bucko?
Yes, sir.
Okay. Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
No, Your Honor.
Are you both satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Yes, Your Honor.
Great. Mr. Bucko, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. How did we want to address sentencing? Is this something that Mr. Ziegler, are you going to be asking for the court to impose jail time?
I may be, Your Honor. I'm not sure what parole is going to do either.
Okay.
But I don't think I'm comfortable proceeding to sentencing at this juncture.
Okay, so Ms. Wagner, I'll just ask that you get in contact with Mr. Bucko and prepare misdemeanor PSI on this one.
Yes, Your Honor. And I will also look into it. I think sometimes with misdemeanor pleas, sometimes I believe it's concurrent sentencing and they are entitled to credit, but I have to look into that further. But I just wanted to put that on the record just in case something changed.
Okay, and that's fine. I guess I want to make sure that Mr. Bucko understands that the worst possible outcome would
Yeah.
be consecutive sentencing with no credit.
Correct. Thank you.
Okay. All right. And then would we transport Mr. Bucko here? Is he still going to be in custody? I'm assuming because of the parole.
Unless something, the assumption, that's an appropriate assumption unless MDOC acts pretty quickly.
Okay, so Mr. Ziegler, I'll just ask that you prepare a writ for Antrim County to have Mr. Bucko transported here for sentencing.
Yes, Your Honor.
Mr. Bucko, do you have any questions about how we're going to go forward with your case?
Usually how long are the sentencing? About how long out is it?
30 days.
Okay.
Yep.
All right.
All right, thank you. That's all for this hearing today, and the court's going to disconnect.
All right.
All right, I do want to go on the record in People versus Willoughby. This is file number 244988. And Mr. Ziegler, I didn't have a chance to look at that file, but did we do a writ on that one?
A writ was done last week, Your Honor. It was sent to the facility. I forget which facility he's at, but it was sent to them. There was some discussion about doing a Zoom writ. I think my office contacted Mr. Trevis about that. I don't think it was ever arranged that way. And so I assumed they would just bring him in person.
Okay. Is there any objection to resetting this and attempting again with the writ?
I have no objection. I was going to inquire if Mr. Trevis had any update about the underlying case that I believe is an Antrim.
Otsego.
Otsego.
Well, and I don't want to get ahead of discussions Miss Wagner and I had, I believe he was maybe arraigned yesterday on that. It had been quite some time. We had adjourned this to catch up to that case, and for whatever reasons, no progress had been made on the underlying file. And there again, I think Ms. Wagner was maybe going to discuss it with Your Honor. She had maybe a broader resolution that I would leave to her. But I think their only real option is to reset it. And maybe something happens in the interim.
All right, Ms. Wagner.
Yes, Your Honor. So kind of messy because one of his counts is linked to a Grand Traverse County case that he's already been sentenced on and currently incarcerated for. Another count is related to a new CSE case out of Otsego County that he was just arraigned on. He also just got arraigned on a brand new larceny in a building case out of Otsego County. So things were not progressing as I originally thought as quickly. So I'm going to try to get the updates from the prosecutor's office out of Otsego County, maybe get with Ryan and Kyle to come up with a resolution on our case, since at the end of the day, he's going to be facing more serious consequences out of Otsego County on the CSE. So hopefully I can have something wrapped up within the next 30 days for his next writ when he appears before the court.
Well, that's what I was wondering. Should we set this out 60 days just to give a little more time for all of that?
We can, and I'm really hoping maybe we can just resolve something on our end. Because I think if we keep pushing ours down, there could be a likelihood he might go to trial on the CSC or something like that. And I don't want to keep lingering ours out. It's already been out there for a long time as it is now.
Okay. Well, I'm going to set it for 60 days. If
Okay.
there's a resolution, or then we won't need that hearing. Or if you want to get it on quicker than that, just let Jennifer know and we can get it on for next month.
Okay, thank you.
Okay. Anything further on that file, Counsel?
Nothing further, Your Honor. Thank you.
Your Honor.
All right. Mr. Travis, did you have any more cases?
I think that's it for. That's everybody I highlighted at least.
All right. Mr. Eller, do you have your client?
Sure.
Mr. West, if you want to come right up to the podium here, please. And we'll go on the record in People versus Blake West, file number 265188. The record should reflect that Mr. West is present here in the courtroom today. But we have counsel put your appearances on.
Ryan Ziegler on behalf of the people, Your Honor.
My name is Craig Elhar after West, who appears today in court to my left.
Thank you. This is set for a status conference or scheduling conference here today. Mr. Elhart, have there been any plea discussions? Do you want to just get this on the trial track? How would you?
We have had some preliminary plea discussions. I'd like to continue those, and I would like to put it on trial track.
Okay. And Mr. Ziegler, how many days of trial do you think we could need for this case?
I think we could get it done in one day, Your
I
Honor.
concur, Your Honor.
And Mr. Elhart, how far out would you like the court to schedule this for trial?
Unfortunately, Your Honor, looking at my schedule, I have 32 days, 32 trials between now and the end of the year. I'm very lucky, but September might be good. I'm sure we can work something out by then if we're able to do so.
Okay. So we'll set it for a one-day jury trial in September. And then I will set it for a final status conference about 30 days prior to the trial date.
Your Honor, thank you.
Are you anticipating any motions being filed?
No, Your Honor.
Mr. Ziegler?
No, Your Honor.
Okay. To the extent there are any, that final status conference would be the motion cutoff. So any motions would need to be filed and heard no later than that date. And then that will also be the plea cutoff. So Mr. West will have one final hearing before your trial date. And so it's important that you stay in touch with Mr. Elhart and that you're ready with any final decisions on any plea offers at that time, okay?
Thanks, Your Honor. He's very good about that.
Okay.
Thank you, Your Honor.
Mr. Elhart, is there any other dates that you need to address?
No, Your Honor. Thank you.
Oh, Mr. Ziegler.
No, you're.
Okay, thank you.
Judge, have you seen Tom Davis at all?
Yeah, I saw him on Saturday, actually.
Did you? How's he
One
doing?
second. 1 second. All right, we'll go on record in People versus Wilk, file number 2651180. Deputy, would you mind just checking the lobby for Mr. Wilk?
Just gonna.
Your Honor, just to let you know, I do have a parole absconder warrant for Mr. Wilkie. He has not been reporting to parole.
Okay, thank you for that information.
No, Your Honor.
Okay. Okay, so this hearing was set for 11 o'clock. It's now 11:05. Mr. Wilkie has not appeared. It's like the way they stand. Mr. Ziegler, do you have any records of whether or not Mr. Wilkie's had failures to appear in his file prior to today?
He has not, Your Honor. He was here at the last court date. He was representing himself and he asked for an adjournment. He said that he hired an attorney by the name of Damian Nunzio. I looked him up. He is a real attorney who's licensed in the state of Michigan, but I've not received any correspondence from him in any way, shape, or form. I also have not heard from Mr. Wilkie on his own behalf since the last hearing.
Okay, and I'll note for the court file does not reflect that he has retained counsel, and my notes reflect the same thing that Mr. Ziegler just indicated as to the last hearing. So based on that and based on the information provided by Ms. Wagner, I think it would be appropriate, given his non-appearance, to have a bench warrant issued. So Mr. Ziegler, if you would prepare that.
I will, Your Honor.
And we'll proceed further with Mr. Wilkie's case once he's arrested and brought before the court. And the next hearing is set for 11:30, so we'll be in recess until that time. Okay, we'll go on the record in People versus Roger Welch, file number 265170. If I could have counsel with your appearances on.
Ryan Ziegler on behalf of the people, Your Honor.
Matthew Connolly, Your Honor, on behalf of Mr. Welch.
Okay, this is set for status conference today. Was set for 11:30. It's now 11:40. Mr. Welch is not present. Mr. Connolly, can you just make a record of any contacts that you've had?
Yes, Your Honor. So when Mr. Welch was here incarcerated, we had a bond hearing, and I believe Your Honor gave him an obtainable bond, which he then posted. I advised him, when you get out, or if you bond out, please contact me. And I haven't had any contact with Mr. Welch since he bonded out.
Okay. Mr. Ziegler, do the people take any position on how to proceed?
Your Honor, the offer in this case is 7411, so it's not like the crime of the century or anything, but it is concerning to me that the bond hearing that Mr. Connolly is referencing was back on March 30th. I'm assuming Mr. Welch posted relatively soon after March 30th. We're now into June, and it sounds like Mr. Connolly's had no contact with his client. Given that, Your Honor, I think a warrant is probably appropriate.
Mr. Connolly, is this an appointment?
It is, Judge.
It is, okay. All right, given that this is a situation where the defendant has appointed counsel, has not made contact in a number of months, and did not appear today, I do think a bench warrant would be appropriate. So Mr. Ziegler, if you would prepare that, and then we'll proceed further once Mr. Welch is arrested and brought before the court. Mr. Connolly, anything else we can address?
No, Your Honor, I'll be around for a little bit here this morning, so if he shows up somewhat late, I'll come right back.
Okay, thank you. Mr. Ziegler?
Nothing further, Your Honor. Thank you.
Okay, thank you.
See ya.
Yeah, it's. Mr. Ziegler, we have one more case, but it's a divorce case.
Thank you, Your Honor.
Feel free to stay as long as you'd like, though.
Stand.
All right.
I think that's what we're running into.
Your Honor, did you say you're done with the criminal docket?
We are, yep.
Okay, thanks. I'll be over here shortly to have you sign some stuff if that's okay.
Thank you.
Thank you.
The sprint.
Okay, we have both parties connected, so we'll go on the record in Frederickson versus Frederickson. This is file number 2615001. And both parties are present by Zoom video. I have this set as a date to enter final judgment of divorce in this case. And Mr. Frederickson, is that how you wanted to proceed today?
Yes.
And Ms. Frederickson, is that how you wanted to proceed as well?
Yes.
Okay, so I'm going to place both of you under oath. I've got some questions that I need to ask each of you. The questions that I'm going to be asking are those that I'm required to ask to establish the grounds for divorce under Michigan law. So if you would both, please raise your right hands. You both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can both lower your hands. Mr. Frederickson, as the party filing for divorce, I'm going to have my questions for you first. Mr. Frederickson, you filed the complaint for divorce in this case and you signed that complaint. Is that true?
Yes.
At the time you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Kalkaska County for at least 10 days?
Yes.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remain no reasonable likelihood that the marriage could be preserved. Was that true when you signed that complaint?
Yes.
Does that remain true today?
Yes.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No.
In the judgment of divorce, you would not be receiving any alimony or spousal support. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that?
Yes.
And have you and Ms. Frederickson already divided up all the assets and debts of the marriage?
Yes.
Do you own any real estate or real property together?
No.
Great, thank you. Ms. Frederickson, have you heard all the questions that I asked Mr. Frederickson?
Yes.
Have you heard all of his answers?
Yes.
Do you have any reason to believe that any of the answers he gave were untrue?
No.
Are you currently pregnant?
No. Not to my knowledge.
All right. And under the judgment of divorce, you also would not be receiving any alimony or spousal support. You understand that you would be waiving that forever as well, and that you could not come back later and ask the court for that.
Yes.
And do you agree that all the assets and debts of the marriage have been divided up between the two of you?
Yes.
Are you asking to have your last name changed?
Yes.
Okay, and are you asking to have that changed to Martindale?
Yes.
Okay. All right, thank you. The court finds that the statutory grounds for divorce have been met by the testimony of the parties. I have signed the judgment of divorce, so your divorce is final as of today. So Ms. Frederickson, that means that as of today, your name will be legally changed. So you'll need to get a copy of this judgment from the clerk's office here in Kalkaska, because when you change your driver's license or other documents, they're going to need to see a copy of the judgment of divorce. Do you have any questions about that?
No, sir.
And Mr. Frederickson, do you have any questions at all?
No.
Okay, thank you. That's all for this hearing today, and you're both free to disconnect at this time.
Thank you.
Thank you.
All right, that's it for our morning hearings. Sure.